Welcome back to the deep dive and our ninth legal snippet law simplified.
Good to be here.
Today we're digging into a court ruling that probably affects, well, almost anyone who drives on national highways.
Yeah, we're looking at the Bombay High Court's decision in Arjun Khanapur versus the Union of India.
Right. And the core of it is about that mandatory FASTag system.
Specifically, the court upheld it. And importantly, it confirmed that charging double the toll if you don't use FASTag in a designated lane. Well, that's legal.
Exactly. So our mission today is to kind of unpack this judgment, understand the reasoning, and figure out what it means for, your daily commute.
Mm-hmm.
We've got the High Court judgment itself, plus insights from SCC Times, IGPR, FICC Lie, Wikipedia, Akhilesh Srivastava's blog, Drishti IAS, Motorfloor, ICICI Bank, P. on ECI, and the Times of India. Quite a stack.
A good range of sources, yeah.
So let's get into it. Where should we start? Maybe the background of FASTag itself.
Good idea. To really get the court's view, it helps to remember what FASTag is all about. It's basically an electronic toll collection system.
Right, the sticker on the windscreen.
Exactly. It uses RFID, that's radio frequency identification technology. Your car passes the toll, it gets scanned wirelessly, toll paid, quick and easy, ideally.
And this wasn't something that just appeared overnight, was it?
No, not at all. If you look at sources like Wikipedia or Akhilesh Srivastava's blog, it was actually introduced way back in 2014.
Okay.
The main goals then were pretty clear. Cut down the traffic jams at toll plazas and push towards more digital payments, less cash handling.
I think I remember a pilot project somewhere.
Yeah, that was on the Ahmedabad-Mumbai stretch initially. Then they gradually expanded it across national highways.
And then it became compulsory for new cars.
That's right, December 2017. If you bought a new vehicle after that date, it had to come with a FASTag.
And the final deadline for everyone else on national highways.
That was February 15th, 2021. That's when it became mandatory across the board.
The judgment we're discussing, the Arjun Khanapur one, it mentions the idea of making nearly all lanes FASTag only too, right?
Yes, moving towards primarily FASTag lanes, maybe keeping just one hybrid lane, perhaps for oversized vehicles or in specific situations.
And people have adopted it. I mean, the numbers are pretty high now.
Oh, definitely. I should mention that by 2023, something like 96% of toll payments were happening via FASTag.
Wow, 96%.
It's a huge shift. And the money involved, it's staggering. Wikipedia and Srivastava's blog point out that in just 1 month, January 2024, the transaction value was over 5,500 crore rupees.
That's massive. From how many transactions?
Over 330 million.
In 1 month.
Just shows how integrated it's become, and getting one, recharging it, is that difficult.
Well, the judgment itself and sources like Motorfloor suggest they're pretty widely available. Points of sale, banks, online.
And recharging online is simple enough usually.
Yeah, and there's even an app, My FASTag, and a helpline number, 1033, for support if people run into issues. Faxley mentions those.
Okay, so the system's well-established, widely used, which sets the scene for the legal challenge. Exactly. This public interest litigation, the PIL, was filed against that backdrop.
And what was it challenging specifically? SCC Times says it was about the NHAI circulars making double tolls mandatory.
Yes, those circulars that kicked in from February 15th, 2021. The one saying if you're in a FASTag lane without a FASTag, you pay double.
So what was the argument from the person who filed the PIL?
The petitioner argued, according to the judgment in SCC Times, that just converting cash lanes to FASTag-only lanes was, well, illegal and arbitrary.
Arbitrary meaning? Like, no good reason for it.
Yeah, basically that it was done without proper justification or fair process. They felt it wasn't a reasonable rule.
Were there other concerns raised?
Oh, yes. The judgment notes they brought up concerns about hardship. Think about people maybe not comfortable with tech or those without bank accounts.
Okay, practical difficulties.
Right. And they even argued it could potentially violate the fundamental right to freedom of movement, essentially making travel harder or more expensive without justification.
And their proposed solution was?
They asked the court to ensure at least one hybrid lane remained open at toll plazas where you could still pay with cash.
Okay, so that's the challenge. What did the Bombay High Court decide?
Well, the bottom line, reported widely, including by SCC Times and in the judgment text itself, is that the court dismissed the PIL.
Dismissed it, so they sided with the authorities.
Pretty much, yeah. They didn't agree with the petitioner's arguments.
And what was the key reasoning? I heard something about calling the double charge a fee, not a penalty.
That's absolutely central. The court was very clear. Charging double for not using FASTag in a FASTag lane is a fee for using that specific lane inappropriately, not a penalty for breaking a law.
And that distinction matters legally.
It does. The court stated this double fee was actually allowed under the existing National Highways fee rules from 2008.
Ah, so the framework was already there.
Exactly. It wasn't something plucked out of thin air in 2021. The rules already provided a basis for charging differently. Seeing it as a fee makes it more like a charge for service or usage, rather than a punishment, which can be harder to challenge constitutionally.
Did the court talk about why FASTag was implemented in the first place?
Yes, strongly. SCC Times notes, the court saw it as a clear policy decision. The goal was efficiency.
Efficiency how?
More seamless travel, reduced waiting times at tolls, which in turn saves fuel for commuters and cuts down on vehicle pollution. Broader public good arguments.
And they felt people had enough time to adapt.
That was another point. The judgment mentions the gradual rollout, the fact it wasn't mandatory overnight. Plus, they highlighted things like cashback incentives offered between 2016 and 2020 to encourage people to get on board early.
So the initial system allowed cash, but the rules were changed.
Right. Initially, cash was an option everywhere, but the rules were amended specifically to bring in this double fee for non-FASTag users in the designated FASTag lanes.
What about that freedom of movement argument? That sounds serious.
The court tackled that head-on. Drishti IAS reported on this too. They basically rejected the idea that the system stops people without FASTags from using the highways.
How did they figure that?
Their reasoning was, you're not barred from the highway. If you don't have a FASTag, you're directed to specific lanes, usually the leftmost one. And if you ignore that and go into a FASTag lane, then you pay the double fee. So it's about traffic management, not outright restriction.
Okay, so it's channeling traffic, incentivizing the preferred method.
Precisely.
Did the court buy the argument that people just aren't equipped for this tech?
They seemed, let's say, skeptical. The judgment text in SEC Times mentioned the court pointed to how widespread mobile phones are.
Good point.
They essentially implied that using a FASTag isn't overly complex, especially compared to using a smartphone, which so many people do. They didn't find the public isn't ready argument very convincing.
So overall, the court saw the policy as rational.
Absolutely. The judgment explicitly states the policy isn't arbitrary or irrational, and it doesn't violate fundamental rights. It's a legitimate policy choice.
Did the NHAI raise any procedural points?
Yes, there was a preliminary objection mentioned in the judgment. NHAI argued that since the petitioner claimed to be personally affected by the double toll, maybe a public interest litigation wasn't the right way to bring the case. PILs are usually for broader public issues, not individual grievances.
Interesting. And they cited precedent, that Uyghur Sugar Works case.
Right. The court brought that up to underline a general principle. Courts usually don't interfere much with government policy decisions.
Unless
the policy is clearly shown to be made in bad faith or is totally unreasonable, arbitrary, or fundamentally unfair. But if it's just a policy choice people disagree with, the courts tend to step back.
Okay, that clarifies the legal side. Let's bring it back to the road. For the average driver, what's the real-world impact of this judgment?
Well, the most direct impact is clarity, I suppose. This ruling solidifies that FASTag is mandatory for smooth travel on national highways.
And the consequence for not having one.
If you enter a FASTag lane without a working FASTag, expect to pay double the standard toll for that plaza. It's a direct financial hit for non-compliance in those specific lanes.
But we should also circle back to the benefits for compliant users, shouldn't we?
Definitely. As we mentioned, sources like E04 highlight the plus points, shorter queues, saving fuel because you're not idling as much, and contributing, even in a small way, to less pollution. Those are real advantages for people using the system correctly.
Were there teething problems with FASTag? I seem to recall some issues early on.
Oh, for sure. Initial adoption had its bumps, recharge problems, tags not scanning correctly, technical glitches. Both Ejirpur and the judgment acknowledge this implicitly by mentioning support systems.
But things have improved.
The system has matured. And as we noted, there are support channels like the helpline and app. The key takeaway is probably check your balance, make sure the tag is fixed correctly before you set off, avoids hassle at the booth.
And looking even further ahead, FASTag might not be the final word.
That's right. It's worth mentioning, as sources like ICICI Bank and the Times of India have reported, there's talk about a GPS-based toll system.
How would that work?
Potentially, it could track your actual distance traveled on the highway and charge you accordingly, maybe even without needing physical toll plazas at all. But that's definitely future-gazing, possibly something post-May 2025, Not happening tomorrow.
Okay, interesting. But for now, the FASTag system and the double fee rule are legally sound.
Exactly. So, summing up, the Bombay High Court's judgment gives a clear green light to the mandatory FASTag system and the legality of charging double toll fees in designated lanes for non-users. The court accepts the reasoning that it's a fee, not a penalty, aimed at efficiency.
So for you, the commuter listening right now, the practical advice is pretty straightforward, isn't it?
It really is. Ensure you have a working FASTag with sufficient balance if you're using national highways. It's the simplest way to avoid that double charge in FASTag lanes and, keep moving smoothly.
It does make you think, though, doesn't it? About how much digital systems are becoming part of everyday infrastructure.
Absolutely. Tolls, payments, so many things are moving that way. This ruling kind of reflects that broader shift towards efficiency through technology, whether we always find it convenient or not.
Definitely food for thought. And if listeners want to explore more,
Well, they could look up the National Highways fee rules themselves or check out NHAI guidelines online. And keeping an eye on news about that potential future GPS system would be interesting too.
great advice. Thanks for breaking that down for us.
My pleasure.
And thanks to all of you for joining us on the deep dive.